Hello everyone, we're the UK delegation and we have the topic of transfer and acquisition of property. Now the UK is not just one country. It's made up of 3 different legal systems and 3 different countries, which are Scotland, England and Wales. For the sake of clarity, and because we're not going to have that much time in a 10-minute video to explain all of the different legal systems and how they work and their intricacies, we're just going to choose 2 of them. So the English legal system and the Scottish one, which are the most different. Without further ado, England is a common law country. It doesn't have a civil code like most continental European countries. Instead, it deals with its transfer and acquisition of property in its Sale of Goods Act. It also must be noted that English property law is not unitary. Movables and immovables are treated very differently. Another thing is that there is no concept of ownership in England. Instead, we use the notion of title. A person with a better title has a claim for a certain property, until a person with an even better title comes along and claims that property from person A. What is very, very important about the English legal system is that it's a consensual one in regards to transfer of ownership. The Sale of Goods Act, Section 17 and 18 relate to the transfer of ownership, but my colleague Jim will be telling you a lot more about that in question 2.
Now I will provide an introduction to the other main legal system found within the United Kingdom. The law of Scotland, known as Scots law, is distinct and separate from English law, although there are areas of convergence and overlap. Scots law is a hybrid system which contains both civil and common law elements. There are 4 recognised sources of Scots law: legislation, legal precedent, custom and institutional writers. But institutional writers are becoming less relevant as they are replaced by case law, and there are no modern institutional writers. Scots property law makes an important distinction between heritable property, which comprises land and buildings which cannot be easily moved, and movable property, which includes essentially everything else, including intellectual property. The law of heritable property in Scotland arose due to the feudal law system, which was eventually reformed in the 1970s. However, the system of law surrounding movable property is based on Roman law. The basic structure of Scots law transfer of property is represented by the equation on the slide, which is contract plus conveyance plus external act equals a transfer of property. Obviously, in reality, it's a bit more complicated than that, but that's the general gist of it. Interestingly, in Scots law, the term assignation simply refers to a transfer of incorporeal property.
Ladies and gentlemen, as my colleague said, I would now like to discuss the UK's position as a whole regarding transfer and assignment rules. So starting off with England and Wales, regarding the transfer of movable objects, the requirement of delivery plays a crucial role, and originally it used to be applied to all transfers of movables. However, 2 important exceptions to this were developed, which exist and apply until this day. Delivery will be held to be unnecessary where either the transfer is based on sale or the transfer takes place by deed. So for example, a gift, which is not a sale, requires delivery in order to complete or perfect the gift, following up from the bundling versus Ashley case. England is a consensual system alongside with Wales, and this is codified in the Sales of Goods Act 1979 at Section 17, subsection 1. Meanwhile, Section 18 in Rule 1 of the same Act deals with the question of what happens if the party's express or implicit intention is absent, alongside with the Darling versus Baxter case. Moving on, England and Wales regarding the transfer of property rights in land. There are 2 systems of transferring titles to land: transfer by deed or transfer by registration. Transfer by deed, which is the unregistered system, however, is in decline, and it is used for the transfer of titles that are not registered in the land registers. However, it is time-consuming and costly. Section 2 of the Law of Property Act 1989 states the requirements for contracts for the sale of land or other disposition of any interest in land. And finally, Scotland. Scots property law governs the rules of property in Scotland, and a fundamental distinction in Scots law is between heritable and movable property. Registration in Scotland is constitutive. Without registration, no real right is created, neither is transferred. The transfer of ownership requires only the registration of a unilateral deed, which has to be signed by the seller and the seller only. And finally, we can conclude that Scotland is an abstract system because the disposition and the transfer are unaffected by the invalidity of the sales contract. My colleagues and I will try to compare the UK's position with some other member states that we have found.
France, in comparison to UK, is a civil law country. Its property law is dealt with under a French civil code, unlike the UK. It's a unified system, so movables and immovables are both treated the same. What is very important to mention is that it's a consensual system, much like the UK, and this is mentioned in Article 1583 of the French Civil Code, where it says the ownership is acquired as of right by the buyer with respect to the seller, as soon as the thing and the price have been agreed upon. So as soon as there's a consensus, there is also a transfer of property. Article 711 of the French Civil Code deals with the acquisition of property in France. Like I mentioned before, France is a consensual system, which means there are no formalities, it's very easy and efficient, and it also protects the buyer, because as soon as the contract is made, as soon as there's consensus, then the buyer is the owner of the property. That being said, it must be mentioned that France is an abstract system, which means that the contract must be valid for the transfer to be valid. If there's something wrong with the contract, for instance duress, then the transfer is not valid. Another thing that's important to mention is that in regards to immovables is that there is a registration system, but it's only for public knowledge, so it's not required by law to register.
Now I will briefly introduce the structure of German private law and provide a comparison with the law of the United Kingdom as a whole. German law is based on the civil code known as Bürgerlich Gesetzbuch. Apologies for my pronunciation. It has heavy Roman law influences. Property law, known as Sacherecht, forms the third book of the BGB. It deals with ideas of possession, property, other rights persons have relating to property, such as movable property and real estate, and how those rights can be transferred. There are a number of key differences and similarities between the law of the UK and German law. Because both legal systems have been heavily influenced by Roman law, they share the idea of the separation of movable and immovable property. One of the key points between the systems of law is the transfer of property. This is known in German law as the abstraction principle, wherein ownership is not transferred by the contract of sale, but instead this merely obliges that the transfer and payment take place. A separate contract is formed for the actual transfer of both ownership of the item to be purchased and the money used to pay for it. Although this is similar to the system used in English and Scots law, it is not identical. In English law, where the contract deals with specific goods, the transfer takes place at the point at which the parties agree it should, in spite of the presence of the sales contract. The intent of the parties is the crucial element, and although it has been said that in modern times little would be needed to infer that the transfer of specific goods happens upon payment or delivery, the intent of the parties remains the most important aspect of determining when the transfer of ownership takes place.